game without knowing the rules. Hello, my dearest friends. Svetlana Shlapak, the founder of UKVisaSuccess.com is here. Can you really win the game without knowing the rules? You can't, and that is precisely my point. Unless you are at the same page with the decision maker who is reaching a decision on your visa application, your chances for success are very vague. And that is precisely why I've created this Know the Rules to Win the Game video series, where I'll be deconstructing all major UK immigration categories. There will be overview videos giving you all major rules about relevant categories so that you can see exactly what the decision makers look at when they consider your applications. And if after watching this video you want some more information, please do check my website and also the description area of this video. There I'll be giving you information regarding the next free webinar which I host in order to help you understand various aspects of UK immigration law. Please help me help others by liking, sharing this video and subscribing to my channel. For those of you who already done this, thank you so much for your continued support. I really appreciate this. So let us deconstruct the next immigration category. And today, my dearest friends, we are going to deconstruct immigration rules for partners of British citizens or those who are settled in the UK or those who are here with humanitarian protection. I draw your attention to the fact that these are the rules for those who make an application in the UK. There are different rules for those who enter the UK from outside the UK and those who are in the UK. They can either switch from other immigration category or they can probably they have already applied as partners to enter the UK, and now they're after 33 months they're seeking to extend their stay here in the UK as a partner. There are 4 fundamental rules which those who make this application need to comply with. The first one, the applicant, this is the partner who makes an application to remain in the UK, is in the UK, so it tells us that this application is when in the UK. The second one is that applicant, the person who makes an application, has made a valid application for leave to remain in the UK as a partner. All this means is that the person has followed the correct procedure. It's always the same. First of all, you have to make sure that you complete the correct form. If you do not complete the correct form, the application will be automatically rejected. There are huge consequences for this, because if it is rejected after your leave expires, then it means you become an overstayer and you leave all your rights to remain in the UK. Therefore, please make sure that you are completing the correct form and this form is up to date, because if you are completing the last, not the current version, but the last version of the form, the application will be refused unless less than 21 days have passed since they've changed the form. Then you will need to pay the fee. Once again, I draw your attention to the fact that there are lots of refusals because of that, and not because people forget to complete the payment form, but because the Home Office has difficulty in recovering this fee. This happens for various reasons. It can be that the credit card got lost or stolen, or there are some other problems with making the payments, and the safest way therefore is to make your payments by postal orders. You'll pay slightly more, but it is the surest way to ensure that the Home Office can take the payment for the application. And even if it is not your fault, if the Home Office cannot take the payment from your account, then the application will be again automatically void. And once again, there are huge consequences, especially for those when the application is refused after their leave expired. You will need to number 3, you will need to submit supporting documents. If you're visa national, which you will be if you're making this application, then you'll need to submit your biometrics. You have to do this within a prescribed period of time. And again, I'm really sorry guys that I keep saying these things, but you have to be really careful. You have to comply with all the requirements in order to make sure that the application is not refused. And that is why I'm here. That is why I'm doing doing all these videos just to make sure that you keep an eye on all these tiny, which may seem unimportant things, but they do make a huge difference to the outcome of your application. So please make sure that after they accept your application and send you a letter inviting you to do biometrics, please make sure that you do this on time. And the last form is designated post. You have to submit it to the appropriate place, and it is very easy because on the application form they always tell you where you have to send your application. Number 3, the third requirement, you have to meet all the suitability requirements. I have found in excess of 20 suitability requirements, which I'm not going to list here in the video because it will be around, it will be very long. And but if you think that you need to check this out, probably the majority of you will need to do that. You may by all means just complete the make a request below this video, and it will be sent to you. And the distinction I want to make is, first of all, suitability requirements is all about whether or not you are a suitable person to remain in the UK. So there will be questions about criminal convictions, if any, whether or not you honestly complete the application form before, whether or not you failed to attend any interviews, or if there are any debts to NHS, or if there were any litigation fees between you and the Home Office, whether you repaid those, etc, etc, etc. There are many of the suitability requirements which you need to check. I would like to draw your distinction in this video between mandatory and discretionary. The only distinction between those is that mandatory is when, if you are caught by one of mandatory suitability requirements, it means that the decision maker will have no choice but to refuse your application. Whereas if one of the discretionary suitability requirements apply to you, then it means that they will have a discretion as to whether or not to allow or refuse your application. And I would like to warn you that normally they do not exercise their discretion, and normally they refuse the application even though they're discretionary. And therefore, please make sure before making this application that none of the suitability requirements apply to you. Once again, you can check this by simply requesting the information by clicking the link below. And the final requirement number 4, is that the person who applies meets all the eligibility requirements unless paragraph EX1 applies. That is the major difference between those who make an entry clearance application and those who are in the UK, because when you make your application from outside, you cannot benefit from paragraph EX1, whereas when you're in the UK, you can. And I will talk to you more about this. This eligibility requirement is probably one of the most difficult for many of you to understand, but I guarantee that if you stayed with me until the end of this video, you will be able to understand all its elements. There are 4 elements in the eligibility requirement: the relationship requirement, and then we have immigration requirement, financial requirement, and English language requirement. I would like to start by analyzing the relationship requirement with you. First of all, the person who applies will need to prove that he is either married to a British citizen, settled, or someone who is with indefinite leave to remain on permanent right to reside in the UK, or someone with humanitarian protection. Both parties should be over the age of 18, and they should not be related to each other. They have met in person. Their relationship are genuine and subsisting. They are legally married. It means that their marriage is recognized by law in the country where it was concluded, and also they are not involved in any other relationship, and they have lived together in the UK since they were granted entry clearance as their partners. And unless they have a good reason consistent with continuing intention to live together permanently in the UK for any period in which they have not done so. So this was our relationship requirement. Immigration requirement is pretty straightforward. You cannot make an application if you are here as a visitor or you have a leave to enter or remain in the UK for less than 6 months. And you are not here on temporary admission unless more than 6 months have passed since that time, or unless EX1 applies. And here you are not in breach of UK immigration rules unless EX1 applies. EX1 stands for exceptions, and I would like to explain them to you right now. Okay, let me first of all explain to you when the paragraph EX1 applies. Let's say someone makes an application and the decision maker looks at the application and they see the person who made an application and they do not meet all the eligibility requirements. It can be a financial requirement or it can be an immigration requirement, as you will see later. So there may be exceptions to that. So what would normally happen, they would normally refuse the application. However, they've introduced these exception rules where the decision maker, after they came to a conclusion that the person doesn't meet the eligibility requirements, they are under the obligation to see whether or not paragraph EX1 applies. And it applies under two circumstances: when there is a child involved and when there is a partner. So the paragraph EX1 applies when the person who made an application who is not eligible under some of the eligibility requirements, but he can prove that he has a genuine relationship with a child, then the application may be granted. What normally happens if the person doesn't meet the eligibility, some of the eligibility requirements, but the paragraph EX1 applies to them, then the decision maker sends them via the 10-year route. So what normally happens if, for example, you are here as a partner, you would normally gain your right to remain in the UK for indefinite leave to remain for an indefinite period of time after 5 years. However, if you fail to meet one or two or couple of eligibility requirements, but your application is not refused because one of the paragraphs of EX1 applies to you, then it means that they will send you via the 10-year route, and it means that you will only be eligible to apply for indefinite leave to remain after 10 years. So this is kind of a penalty, but it's probably not as harsh as just send the person back to their country of origin. And so I'm glad that these exceptions are here. So let me explain them to you. First of all, let us concentrate on the child. If the person who makes an application can prove that they have genuine subsisting relationship with a child who is in the UK under the age of 18, and he's either a British citizen or he has lived in the UK for a continuous period of at least 5 years immediately before making the application, and it would not be reasonable to expect the child to leave the UK, then the person will successfully argue that paragraph EX1 applies. Or if this doesn't apply, then you can argue that you have the same relationship with a partner. So the partner will need to be in the UK, either as a British citizen or someone with indefinite leave to remain or permanent residence, or they have a refugee leave or humanitarian protection, and they can prove that there are insurmountable obstacles to family life with a partner continuing outside in the UK. Let me explain what these are. Insurmountable obstacles means that there are very significant difficulties which prevent the parties living outside of the UK, and they normally consider the applications on its own merits. They look into every single circumstances of each particular case. So there is no such a strict, straightforward rules, but they normally take into consideration these factors: the couple's ability to lawfully enter and stay in another country. Normally, this is where the applicant is from, and then they will consider if there are any cultural barriers for them to do so, and whether or not there is anyone ill, and this illness, whether it will prevent them from residing in their country of origin. And also they will they will consider country's situation at the time of reaching the decision. And this is in essence all what this paragraph EX1 means. So whenever I say that unless paragraph EX1 applies, it means that the decision maker, if this if one of the eligibility requirements is not satisfied, then the decision maker will have a look at paragraph EX1. I would like to warn you that the threshold of cases where paragraph EX1 applies is incredibly high, and therefore please by all means try and meet the eligibility requirements without applying this EX1, not only because you will go via the 10-year route as opposed to 5-year route, but also because in these types of circumstances, normally, especially when there are no children but only a spouse is involved, normally this application are refused, and you would probably need to argue your case at the tribunal. So please make sure that you do your best to meet the eligibility requirements before submitting your application. And then we have the exciting financial requirements. Everyone is confused about this requirement, but it's only because there is a lot of information to cover. I promise you that it's all will be pretty clear to you before the end of this video. And also I've created some additional videos clarifying various bits and pieces. First of all, there is a minimum income requirement, despite the fact that many of us were trying to we're opposing this 18,600 pounds. It's still there. And they also say that, so this is only if you have one partner. If there are children, visa national children under the age of 18 who are dependent and they're not EU nationals, then you would need to add on top of this 18,600, you will need to add extra 3,800 for the first child and 2,400 for each additional child. This is very important for you to remember, that you can only meet the minimum income requirement if you can prove to the Home Office that your income is from one of the permitted sources. There are only 7 categories. There are only 5 permitted sources, and there are only 7 categories which the Home Office would accept. And if you cannot, if the source is not permitted by the Home Office, that it will not be accepted. Then they will automatically go into looking into the EX1 paragraph, because if it's not in the permitted income requirement, then unfortunately it will not be accepted. I've created a separate video where I explain what these permitted sources are, and yet another video where I explain I give various examples, because it's notoriously the rules are very difficult to understand. I completely agree with this, and I've prepared a number of examples where I illustrate how this is being calculated by the Home Office. If you have difficulty proving that you meet the minimum income requirement with your income, then you can meet it with your savings. And the formula for calculating is this. Let's say we have a couple, and their income is 15,000 a year, as opposed to 18,000, the minimum requirement, and they don't have any dependent children who are visa national. So let's say we only have a husband and wife, and the couple's total income is 15,000 pounds. And they are willing to meet the rest by the savings. How much do they need to have? All we have to do here, we have to take the 15,000 pounds and work out the shortfall. So all we have to do, we have to deduct it from the minimum income requirement, and we are left with the amount of 3,600 pounds, and we have to multiply it by 2.5, which is here, and then add sorry, so we're left with 9,000 pounds, and then we have to add additional 16,000 pounds, because only after 16,000 pounds they can take your savings into consideration. So the answer to this question is this: a couple will need to have, a couple with a shortfall of 3,600 pounds, the couple where they earn only 15,000 a year, will need to have an extra 25,000 pounds in order to meet the minimum income requirement. And if you want to see more examples, just have a look at one of my videos where I explain how all these calculations are done. Also, you can be exempt from meeting the minimum income requirements if you are in receipt of one of these benefits. If this applies to you, just pause the video and see if the benefit which you are getting is on this list. And also, if you would like to be exempt from meeting the minimum income requirement because you're in receipt of eligible benefits, you will need to prove that you were accommodating your spouse without recourse to public funds, without additional recourse to public funds, I should say. And then, so if none of these exceptions apply, you will need to show that you will be adequately accommodate your partner. So it will not be statutory overcrowded, and the property doesn't contribute public health regulations. And the last element of the eligibility requirement is English language requirement. It can be met in various ways. Number one, if you're from the majority English speaking country, then you meet this automatically. All you have to do, you have to provide your passport confirming that you're from this country. The second one, you have to pass a test, and there is a difference between the two. If you are switching from another immigration category, then all that you have to do, you have to pass the test, the speaking and listening test at the level A1 of the Common European Framework of Reference for Languages. However, if you have entered the country as a spouse of a British citizen, then you have to go above this level, and you have to prove that you know your English language. You have to pass the test of speaking and listening at the level of A2. So you have to go one level above. If you have gained bachelor, master's, or PhD degree in the UK, then this will be accepted as well. Or if you have done this abroad, then and NARIC UK accepts this, then you have passed this test as well. And there are also some exemptions to passing the test. You can be over the age of 65, or there is some exceptional compassionate circumstances, or you have disability. As I mentioned in my previous videos, the threshold is incredibly high, and therefore, guys, it's probably better for you to pass the test and do not try to, unless one of these exceptions apply to you, please do pass the test. And this was it. This was all what we needed to know about the immigration rules for partners of British citizens or those who are settled in the UK who want to make their further leave to remain application when in the UK.